Hello, my fabulous, beautiful fellow seekers. I hope you all are doing well. This was quite an unexpected video I just made. I posted one earlier today about Daryl Brooks being in court yesterday. He wasn't the only one. Chad Doerman was in court yesterday, and he waives his right to a speedy trial. Surprise, surprise. Of course he would do that because, let's face it, I suspect his goal is to have the DP removed, and waiving the right to a speedy trial gives them more time to what I assume is going to be build his plea of insanity case. So let's take a listen and see what they're going to do with this monster.
State versus Chad Doerman. Mr. Doerman is present with counsel. Mr. Myers. Mr. Keynes is excused today as attending the graduation ceremonies of his son. On behalf of the state, Mr. DeCaldy, Ms. Laura Barron, Allen, Ms. Terpstra, and Mr. Tharp. And the court reporter is obviously here as well. This matter was set today for, in essence, a pre-trial to address the motion that was filed on April 30th on behalf of Mr. Doerman pursuant to 29-29-025, colloquially referred to as the Serious Mental Illness Statute, or the SMI motion.
Okay.
I don't need to go through the motion itself. It speaks for itself, and we're here to address the scheduling for this. We had initially a brief pretrial on Monday of this week when the issue was first raised. Nothing of substance was really conducted in that in-chambers pretrial, other than advising that the motion was going to be filed and we needed to address the timing of the motion and the parameters of that motion. It's fairly new statute, it's 3 years old, so it's fairly uncharted at this point in time, but nevertheless, that's why we're here. I had a pre-trial just before coming out here again, nothing of real substance other than discussing some potential dates so everybody can review their calendars. And if I could, initially, Mr. Myers, it's your motion. We have had some discussions, and I know on behalf of the state, the motion, Mr. Myers, reflects that you will file your evaluator's report, not file it, you will provide it to the state. It's obviously not something that's being filed of record, but you will provide that evaluation to the state not later than June 3rd. Is that correct?
Yeah, that's correct, Your Honor. We have communicated that time frame to the person working on our team on this issue, and we will meet that deadline.
All right. And on behalf of the state, Ms. Barron Allen, you want to address a couple of things. One, the request to appoint an expert on behalf of the state and the time in which you may be able to have the doctor complete the report.
Thank you, Your Honor. In conjunction with 29-29.025, we would be requesting the court to appoint Dr. Carla Dreyer as an expert in order to rebut any report or opinion offered by defendants in this case. We have spoken with Dr. Dreyer, and she has indicated that she will work and do her best to have a report done by July 3rd. Actually, she's coming into this much later than the defense expert who has had 9 months to meet with Mr. Doerman and begin working on this report, but she is in anticipation. She has started reviewing materials in this case, so she will work to have that report by July 3rd.
And 29-29-025-D1 does recognize that when this issue is raised, and the burden is obviously on the defense, but it affords the prosecutor the opportunity to present evidence to contest the diagnosis, and obviously that would include expert testimony, at least as far as this court's concerned, expert testimony from a qualified doctor, and so I will appoint Dr. Dreyer to pursue the matter as on behalf of the prosecutors. With that said, we've also discussed that this is, while the statute labels this as a pretrial hearing, it's really a much more complex and detailed hearing. And as I call it, it's not a pretrial hearing, it's a pretrial trial, simply limited to whether the death penalty can be eliminated or can be maintained based upon the statutory conditions there. And it's my understanding that the parties should be able to go forward with that hearing on August the 5th. And that's the date we've selected. Correct, Mr. Myers, you're in agreement with that, August 5th?
We are, that's an agreement.
And I know on behalf of the state, August 5th. Could be 2 days, could be 3 days. We don't really know. Also, on not later than July 8th, there needs to be, the parties need to provide reciprocal discovery at a minimum. Witnesses who will be called to testify on each side of the aisle, if it were. If there are exhibits that would be admitted, I'd like to at least have a list similar to what we do in a trial, identifying what exhibits may be presented by both parties by July 8th. And obviously, with the motion being filed at the time it's been filed and the circumstances we just discussed, the trial on July 8th is vacated and will not go forward on July 8th. And I know Mr. Myers, we've discussed circumstances regarding the time waiver, and it's my understanding that you reviewed with Mr. Doerman the fact that the trial is going to be continued, that this hearing is going to be held, and obviously the court will need time to do its due diligence to review the matters once the evidentiary hearing has been completed. But nevertheless, you've indicated to me he's willing to waive time at least until January 31st of next year in order to address a new trial date if it can't be addressed prior to that. Is that correct?
That is correct, Your Honor. This is the time I do have here in hand the proposed statute to that effect with Mr. Doerman's signature and my own regarding our agreement to waive through January 31, 2025.
And just briefly, Mr. Doerman, I know that Mr. Myers and Mr. Haynes have been representing you, but they discussed these matters with you, in particular the waiver of your speedy trial rights, as Mr. Myers has just stated.
Yes, Your Honor.
And you're in full agreement with that?
Yes, Your Honor.
Anything else you want to address?
I'll just quickly add, I did affix Mr. Haynes' signature on his behalf. I have been in communication with him since yesterday afternoon and throughout this morning, so he too understands and concurs with this decision.
And you can hold on to that. I'll get it when we're finished. And then I know, on behalf of the state, there were some additional matters you wanted to address.
Correct, Your Honor. The state does have concerns, multiple concerns, and the first is since the July trial is being vacated due to the SMI hearing, which we do understand. The fact that we are unable to pick a subsequent trial date at this point is concerning to the state. We are aware that the court is retiring at the end of the year. The sole candidate, to my knowledge, is Judge Nagel, who, again, assuming that he takes the bench, would not be death penalty qualified until mid-April at the earliest. So the state does have concerns in that regard. We would ask, based on Marcy's law, we've spoken with the surviving victims. They want to Obviously, they understand that this is a long process, but they do want to have this wrapped up as soon as possible, so that they can begin to close this chapter of their lives and move on from the court process. So that being said, we discussed the possibility of having this re-rolled within our own court. We are going to look into that and see if that is a possibility. We've also discussed with Mr. Meyer the possibility of requesting a death penalty certified visiting judge for the purposes of continuity, perhaps to even come in for the SMI hearing and then hear the trial, just again so we can set a trial date, again, hopefully before late summer, early fall of 2025. Again, we would like to have this trial in a timely but speedy fashion. So those are our concerns. It's my understanding that Mr. Meyer would have no objection to the state kind of exploring those options of a death penalty qualified visiting judge and potential legal.
Yeah, but let me just qualify. We did our quick chat before coming on record between counsel. It was my understanding we were talking about a potential death qualified visiting judge to take over after the SMI litigation and stuff. I'm just saying that out loud on my feet. I had anticipated that you were thinking about changing the guard even for the SMI litigation.
Well, we reach out and see how that would work with the Supreme Court, whether it would just be for trial or whether they prefer.
That I think could portend even further delays, because this court obviously is prepared to schedule that 2 or 3 day hearing as it already has. If a newcomer arrived from out of county, who knows how that could get scheduled.
My entire point is we would be looking for information,
I understand.
whether or not we can do that.
Well, as I would say in judges' circles, if you will, I'm aged out. Constitution provides that if I was older than 70 before I was able to run for re-election, before my term started, I could not run, and I'm certainly older than that. I'll be 74 in December, so I'm aged out. I also understand the complexities of this particular issue. I'm certainly not clairvoyant, but the decision in this case would have significant ramifications on the very nature of the trial. Obviously, if I determine that the defense has not proven by preponderance of the evidence, as the statute requires, that he fits within the statutory parameters, we go forward with the capital case. Death penalty stays on as a potential penalty. If I find the other, then the death penalty, he is ineligible by the statute to be subject to the death penalty. And that obviously would change this most dramatically. And most dramatically from the standpoint as this was set in July, we had summoned in 750 potential jurors, prospective jurors. We had sent out in early April an extensive jury questionnaire, which is done in every case, death penalty case, and those have been returned, and we're starting to obviously process those. And that's, if the death penalty still remains, that changes. We still have to go back through that. And we have to do that in a timely fashion. And we just have to deal with matters as they are raised. And as as I indicated earlier, I mean, the not guilty plea was just filed about 90 days prior to trial. This was filed just 60 days prior to trial. Nothing inappropriate. They filed it this time. It's casting no aspersions whatsoever on the matter. The statute, 29-29-025, simply says this can be raised at any time before trial, which means it could have been raised the day of trial or the day before trial, which would have been certainly something thankful that we're not facing that, to tell you the truth. So, with that said, the trial obviously will be vacated. I'll put a separate order out on what we've discussed, the timelines here. Obviously, there's time between now and then to flesh out other issues regarding setting the trial date and things along those lines, and we just have to move forward as best we can. Anything further on behalf of the state? Okay, Mr. Myers?
No, thank you.
All right, thank you. We'll be adjourned.
Well, there you go. There will not be a July 8th trial for Chad Doerman. It looks like nothing will be happening trial-wise until 2025. And we'll see, I guess, if the DP gets removed from the table, which is, I'm sure, their biggest intent, because, oh my gosh, I just don't understand how he can just go on and live his life, and I can't imagine he's living his best life, but with all the hopes and dreams he could have had with those 3 beautiful baby boys, and the mom and the sister, his stepdaughter, are left with his mess and trying to live their lives, which I can't even imagine how they're doing that. But there's that for Mr. Doerman. So we'll keep an eye on that, but it doesn't look like much will happen until sometime 2025. So I thought y'all might be interested in that, those of you who have been following the Chad Doerman case. And there will be more videos to come on all of our people we've been following. So with that, I will close for now. Thank you so much for watching, commenting, subscribing. I love you all. Be kind to everyone. Be kind to you. And I'll see you the next time.